Okay, let's begin our last panel of the day. So we've had a really extraordinary day so far. Our final panel looks back to the discussions we've had up to now, but also forward. Our speakers, all of whom are top-rate First Amendment scholars, will be discussing the future of free speech. We've been given a rich context against which we can consider that future direction, and will now be able to benefit from the wisdom and insights of our final panel members as they reflect on what's next for the freedom of speech. Our first speaker today, this afternoon, will be Stephen Shapiro, the National Director of the ACLU. Second, Robert Korn-Revere, a partner at Davis, Wright & Tremaine. Third, Bert Newborn, the Norman Dorson Professor of Civil Liberties at the NYU School of Law. And fourth, and certainly not least, my friend and colleague Nelson Tebbe, who's a colleague of mine here at Brooklyn Law School. So without further ado, I'll turn this over to Stephen.
So thank you very much. Thank you all for sticking in here all day. I want to begin with a confession and an apology. The confession is I do not have a PowerPoint. The further confession is I have never done a PowerPoint. And the further confession beyond that is I have asked my wife to make that the epitaph on my gravestone when I die. The apology is that I have to leave a little bit early in order to catch a plane, so I'm grateful for being allowed to go first. But when I get up and leave in the middle of this presentation, please do not take it as a commentary on anything anybody else is saying. So let me just begin I just have really a few points to make. One of the luxuries of going last after a long and engaging discussion of the sort we've had today is that you can be fairly confident that everything that needs to be said has been said, and we have the great luxury now of just ruminating. You can tell that because the title of our panel is The Future of the Fifth Amendment. It's pretty unbounded and amorphous. So let me start by saying, and I hope this is not disrespectful to my good friend Joel Gora, as I am in agreement with several of the earlier speakers on this threshold question. I do not actually believe the First Amendment is under fire. I think, to be sure, there are a series of difficult and important First Amendment questions, many of which we have been discussing during the course of the day. But if the core principle of the First Amendment is that the government may not censor or punish speech because of disagreement with the ideas that are expressed in that speech, I think that principle is pretty well entrenched in American First Amendment law, and that fortress is not about to be breached anytime in the near future. So if the question is, are we going to have laws in this country penalizing hate speech? I think the answer to that is no. Are we going to have laws in this country penalizing the glorification of jihad? I think the answer to that question is no. Are we going to have laws in this country penalizing seditious libel, criticism of the government? I think the answer to that question is no. That is very unlike both the historical and the contemporary experience in many other Western democracies. So you may have seen a story in the New York Times today about how there is a serious crackdown on speech throughout Western Europe, and they were focusing on Spain. The kinds of stories arresting somebody for doing a Punch and Judy puppet show that was seen as a critique of government policy is, I think, fairly unimaginable in the United States, and I don't think that that is going to change anytime in the near future. Second point, I do not think that First Amendment law is going to change dramatically with the death of Justice Scalia and his replacement eventually by another justice on the bench, whoever that justice may be, even assuming that justice is far more liberal than Justice Scalia has been on many issues, and it's hard to imagine how it could be anything else. The one place where I think there could be a change in First Amendment law as a result of the change in the personnel in the court, and this is not insignificant, has to do with corporate speech. And that plays out in the political context in Citizens United. It plays out in the commercial speech context that we were talking about earlier. But if you go back to this core principle, we don't put people in jail because the government doesn't agree with what they were saying, and we don't otherwise penalize them or make them subject to civil liability. Probably the paradigm case for that in recent years is the Westboro Baptist Church case that people were discussing earlier today, Snyder versus Phelps. The vote on the court in that case was 8-1. The only dissenting justice was Justice Alito. So that law is pretty solid. The third thing I wanted to say is when we were having the discussion earlier today around hate speech, and the relationship between free speech and equality, a difficult, a fraught, and very much a timely discussion. I think in some ways we may have made it too easy on ourselves, if that is possible. Because the way the question was framed this morning, and it was framed in absentia by Nadine Strassen, a good friend and predecessor of Susan Herman as president of the ACLU, Nadine began her remarks by saying, well, we already have declared whole categories of speech unprotected by the First Amendment. True enough, including threats and harassment and fighting words, defamation, obscenity, a couple of other categories. And so she said the question we are now debating is whether or not the state can otherwise penalize speech that causes a psychic injury but is not covered by any of those categories that we've already said are outside the First Amendment. That's not the way the issue comes up, I will tell you, at least within the context of the ACLU, where we debate these questions all the time. The place that the rubber hits the road is defining what constitutes harassment. And the definition of harassment under the law is severe and pervasive speech or conduct that creates an objectively hostile environment that interferes with the equal either educational or employment opportunities of somebody, right, on the basis of a protected characteristic. So it's not enough simply to say we punish harassment. As in so many issues, the fight is a definitional one. And I don't know any simple answer to that question. I don't think those questions can be answered in the abstract. They can only be answered, as somebody again said this morning, by applying law to facts in the exercise of judgment. And people's judgment on those questions is going to vary, and any individual's response is going to vary depending upon the facts as they are presented in any given situation. The next thing I wanted to say is, while I think the fortress of the First Amendment remains secure in the United States, I do agree that this is a pivotal moment for First Amendment law. And I think it's a pivotal moment for First Amendment law for the following reasons. First Amendment goes back, Floyd Abrams was doing constitutional history this morning. First Amendment goes back to the adoption of the Bill of Rights in 1791. A fact that is always a surprise to many foreigners is that the first decision by the United States Supreme Court seriously interpreting the meaning of the First Amendment did not occur until 1919, 128 years after the First Amendment was adopted. So the history of modern First Amendment law is only a century old, and the real history of the First Amendment is pretty much 50 years old for all intents and purposes. But for most of that history, we have operated under a premise, a widely shared premise, that what I would describe as the three enduring values of the Constitution, liberty, equality, and democracy, were all mutually reinforcing. And so if liberty in this context means free speech, because liberty includes free speech, the widely held belief was that more free speech promoted equality, more free speech enabled democracy. Both of those premises, I think, are now under attack, may not be the right word, but are being seriously re-examined. Not for the first time, right? The fight between free speech and equality bubbles up periodically, right? It was a big issue back in the 80s with the whole feminist critique of pornography. It's always been an issue in terms of hate speech and racial equality. But I think what gives the discussion a special oomph now is that it is not only the tension between liberty equality, but the tension between liberty equality and democracy. And the democracy issue is the issue that was discussed during the campaign finance question, which is how do you equate free speech with the economic inequality that gives some people more speech than other people, right? And so you have a three-legged chair that now feels wobbly on all three legs. And I think that is what makes this a moment when people are holding conferences like this. The last thing I'll say, and then I'll step down and turn the microphone over, is I also think we are at a moment in history where there's a lot of doctrinal instability in the First Amendment in ways that we have not spent a lot of time discussing today. And I'm just going to run down 4 or 5 areas where I think that is true. And one has to do with the application of strict scrutiny to restrictions on speech, right? That it has for a long time been the case, not only in speech cases, but in constitutional law more generally, that to apply strict scrutiny is to essentially condemn the law that is being subject to strict scrutiny, right? I know of only 3 cases, maybe other people in the room know of more. I know of only 3 cases in First Amendment law where the court has applied a strict scrutiny and nonetheless upheld the restriction on speech on the grounds that the government has met its strict scrutiny burden, right? One is a case that goes back several decades that has to do with electioneering, restrictions on electioneering outside polling booths. You know, the line that says you can't do electioneering within 100 feet of the polling booth. And the court said, well, that's a content-based restriction because it's not as though they're prohibiting all speech within that 100-foot buffer zone. They're just prohibiting electioneering speech, but there are good reasons having to do with a history of corruption and intimidation that justify this. And so we're going to uphold the regulation even though we're applying strict scrutiny. But what was really happening is they were applying strict scrutiny, but it felt, I think, like a time, place, and manner regulation to them in some ways, so it became a sort of strict scrutiny light. But the other 2 cases in which the court has applied strict scrutiny to speech regulations and upheld them have both happened within the past several years. One is in the national security context, a case called Holder versus Humanitarian Law Project, which upheld the material support provisions of federal law against a First Amendment challenge. John Roberts writes the opinion. It says, the government is trying to criminalize the speech because of the content of what is being said, but national security is obviously an overriding state interest, and we think the statute is narrowly tailored. We will therefore uphold it. And then they did it again, I think it was last term as opposed to 2 years ago, in a case called Williams-Yulee versus Florida State Bar, which was a restriction on campaign fundraising by judicial candidates. Court said strict scrutiny applies because it's speech, but we're going to uphold the law notwithstanding the fact that strict scrutiny applies. I don't want to debate whether any of those decisions was right or wrong on the merits, but I think the idea that the court is now upholding laws after applying strict scrutiny, restrictions on speech after applying strict scrutiny, has potentially serious ramifications for free speech law going forward that we need to think about more carefully. Secondly, the government has in recent years expanded the so-called government speech doctrine, which is attributing speech to the government as opposed to individuals. They have done that in a couple of ways. They did it in last term in the license plate case where the Sons of the Confederate Veterans wanted to get a license plate that had the organizational logo on it, which was a Confederate flag. Texas said, we won't give it to you. Supreme Court said, that's fine. The license plate belongs to the state. Everything on it is therefore government speech. And the significance of labeling something as government speech is the First Amendment does not apply when the government is the speaker. So once you put it in the government speech box, you've written the First Amendment out of the equation. The license plate case may or may not have been a significant case. Probably a more significant case is a case called Garcetti versus Ceballos, which is a public employee case where the court said anytime a public employee is speaking in the course of his job, he's speaking as a public employee and not as a citizen, and he has no First Amendment rights as a public employee. His official speech is essentially government speech to which the First Amendment does not apply. And that has all sorts of serious ramifications. The court's decision a year or two ago, somebody mentioned it earlier today, in Reed versus Gilbert, which very broadly defined what is or is not a content-based regulation, opinion by Justice Thomas. I'm generally all for saying government regulations are content-based and therefore subject to strict scrutiny. His definition was anytime a statute on its face distinguishes between categories of speech based upon the words that are being said, it is content-based and triggers strict scrutiny. I think that is an inherently unstable line that cannot hold. And so there is going to be, so one example that I think was given in the opinion is if a city adopts an ordinance that says you cannot put up any signs on the public right-of-way except for a sign that says blind driveway to warn motorists who are coming down the block that they may not see your car coming down on your driveway. So that's the only sign that's permitted. Every other one is prohibited. Does the government have to survive strict scrutiny in order to adopt that zoning regulation? Hard to believe, but that leaves the law in some sort of unstable position. And then the last place where I think there's great instability in First Amendment law has to do with the entire public forum doctrine and the way the Supreme Court in particular defines limited public forums. Limited public forums are not forums that are open for all purposes to expressive activities like the public streets. They are government forums that have been open for certain purposes. And once open for certain purposes, the government is not allowed to discriminate within the definition of the forum they have defined. And the problem arises when a speaker shows up and says, you're letting this other person speak in the forum, why are you not letting me? Courts are entirely confused about whether that is a content-based exclusion from the forum or simply a defining characteristic of the forum, which is therefore permissible. So I think at the mega level, we have this liberty, equality, democracy wobbliness in our First Amendment stool, and on the doctrinal level, we have a lot of the tools that we have been using for the last several decades to analyze First Amendment cases that don't seem as clear and straightforward as they once did. And the future of the First Amendment will answer all those questions. So thank you very much.
Well, thanks everybody for hanging in there for this last panel. Thanks to Joel for inviting me and to the school for tolerating me. As being one of the two private firm lawyers that were allowed to be among these academic luminaries, we try and keep up. You know, we just do this stuff for a living. We're the mechanics. These guys are the real theorists. But when you see these cases come and go day after day, year after year, it does give you something for perspective on it. What I'm going to try and do is pull together some of the threads that have been presented in what I think have been a series of fascinating and really well-stated positions in the earlier panels. So the future of the First Amendment, no small topic. Since we've been talking about this all day, I think it makes sense to actually review the words, not just the 14 words that Professor Piety put up there, but all 45 of them, and try and get a sense of what direction this is going. But I think the important thing to think about when you're talking about what's happening with First Amendment law is to realize that we're not just talking about a legal problem, how the cases are going to come out, who's going to be on the Supreme Court. The future of the First Amendment is going to be determined by much more than the law, and I really think of it as being a function of three different things. First of all, there is the rule of law, so depending on how the Supreme Court interprets those 45 words is critical, particularly when compared to the way other free nations manage the issue of freedom of expression. But secondly, we need to be able to stand up to the courage of our convictions, that these are, as the Supreme Court said in Tinker versus Des Moines School District, hazardous freedoms. They're the kinds of freedoms that are not for the faint of heart. And then finally, the question of the spirit of liberty, and that is whether or not we understand or are even interested in being a free society when it comes to these difficult freedoms of free expression. So just to try and synthesize where we've been today, you'll notice that a lot of the discussion has been on various types of speech, troublesome speech, hate speech, campaign speech, commercial speech, and a lot of the discussion is how can we get this speech to be a little less free? In other words, how can we deal with a Supreme Court that has gone too far? Have they really gotten the balance right when it comes to interpreting what those 45 words mean? And Professor Waldron, I think, presents his position eloquently. You should read his book, The Harm and Hate Speech. I think he had a very reasoned presentation today. But the idea is, as far as I can understand it, is that we should deal with these free speech issues more as Europe has and balance these free speech interests in a way that allows more sanctions for what he would call hate speech. Secondly, in terms of campaign speech, Professor Hassan wants to see a change on the Supreme Court that will change the recent decisions that have found more First Amendment rights in striking down various kinds of campaign finance reform. And Professor Piety wants to see the commercial speech doctrine substantially changed and cut back. Actually, based on her remarks about the various of the cases like Stevens, Snyder versus Phelps Brown versus EMA and U.S. versus Alvarez, it doesn't stop with commercial speech, but I take her at her word when she says she's a big fan of the First Amendment. And then, appropriate to this panel, I did want to spend a little bit of time talking about Bert Newborn's new book. Fascinating book. Again, I recommend that you read it. And the idea behind it is that we need to fundamentally change the way we look at the First Amendment. These, what I think you called it suffocatingly strict scrutiny for many of the recent cases, and focusing on these same ones, Stevens, Phelps, Brown versus EMA, and Alvarez. And I have to say I'm a little bit hurt because I participated in all of those cases one way or another, either as counsel of record for amici or as co-counsel. And basically saying that it goes too far. And what you really need to do is read the First Amendment like a poem. It is Madison's music. And it strikes me that this is an interesting take on originalism, but I really see it more as an argument from intelligent design. And it's every bit as valid, I think, as religious fundamentalists who argue intelligent design, with, I guess there's one difference, and that is James Madison actually existed. But, you know, the idea is that if you read the First Amendment this way, you'll come out with different answers. You'll have a more collectivized idea, that the idea of the First Amendment really is to create democracy rather than to focus on individual rights. There are only a couple of problems with that, and one is that James Madison didn't write the First Amendment in the form in which it was finally adopted. And I think your Chapter 10 does a good job of talking about how it went through committees and was put together in the way that it was. And there's not the slightest indication that it was meant to be read in the way that it is suggested. Well, what I think is most interesting, and here's where I think we part company on interpretation, is the idea that if you recognize a separate freedom of the press separate from freedom of speech, which I agree you should do, but for different reasons, I don't think you would come out by saying, as you suggest in the book, that you should water down New York Times versus Sullivan. I would agree with you. It would be a good thing to recognize a reporter's privilege, but I don't know how to get from one to the other. And again, suggesting skepticism about those four cases. We could do a seminar on just the reasons for that, but I don't know how you would get, even in reading this as a whole, a way to restrict First Amendment rights in those other ways. So that's kind of where we are with an academic focus on the First Amendment. But I think a probably more direct way to talk about the First Amendment in the legal sphere is to look at what's going on in the Supreme Court. And I agree that there's no real danger that we're going to see a sharp turn, given the vote counts of these major precedents on the court. Having one, even a pivotal justice, step down isn't going to change that. Or actually, he didn't step anywhere, but he's gone. And so I think the court is going to pretty much stay the course where it is. But I think it is useful to look at something that Floyd Abrams was talking about this morning, and that is some of the theories that are bouncing around on the court. Floyd mentioned Justice Breyer's notion of proportionality, or again, sort of a collectivized notion of the First Amendment. And this, I think, is one of the reasons why the 7 most dangerous words in First Amendment jurisprudence are opinion for the court by Justice Breyer. When you read his opinions, you literally cannot tell the difference between his concurring opinions and his dissenting opinions. You read the principles on which they're created, and you honestly don't know which way the court is going to come down. The idea of proportionality is that everything is really pretty much up to intermediate scrutiny, that strict scrutiny is really a bad thing. And what you do is you look at whether or not the value of the speech is worth protecting, how important the speech value is. You look at how important the government value is, and you try and figure out which way you want to come out. So in United States versus Alvarez, the case in which the court struck down the Stolen Valor Act as being a violation of the First Amendment, he came out saying, yeah, this is a bad law, but I would have looked at it in an entirely different way. Of course, Sorrell versus IMS Health, which was the data mining case, he dissented and again applied the exact same test, proportionality, because he simply opposed different values in his analysis of those issues. Now, it's interesting. I was doing a little bit of reading into decisions under the European Court of Justice and the European Convention of Human Rights, and it occurred to me that what Justice Breyer was doing is really applying law the way it is applied in Europe when it comes to free expression. And just as I turned in the paper that I was doing the research for, he released this book, The Court of the World, where he says, yeah, that's what I'm doing. I'm applying this the way you would. The concept of proportionality comes from the way European courts approach this. Now, of course, the reason why that is, I think, in some significant tension with the First Amendment is that the European Convention of Human Rights imposes a very different rule of law than does the First Amendment. And I don't think you can reread the First Amendment to get there. Now, if you read the first clause in Article 10 of the European Convention, so far so good. You know, it says everyone has the right to freedom of expression, including the freedom to hold opinions and receive and impart information and ideas without interference by public authority, regardless of frontiers. Now that sounds like really strong, robust protection for free expression, doesn't it? But you have to keep reading the fine print. Except, it may be conditioned or restricted as prescribed by particular national laws, is necessary for a democratic society, in the interest of national security, territorial integrity, public safety. It's like one of those radio ads for pharmaceuticals where at the end you have someone reading as fast as they possibly can all of the conditions that might kill you. Well, that's kind of how the European Convention works. You also have Article 17, which says, notwithstanding these protections for free expression, if the aims, if it conflicts with the aims of the preservation of a system of democratic values, then it isn't protected at all. So the basic differences between the European Court of Human Rights approaches free expression issues and the US Supreme Court does is really very different. We have limited categories of unprotected speech. Steve Shapiro was mentioning what they are. And as the court has interpreted them through the course of the 20th century, they have, the number of unprotected categories has diminished and they have been narrowed. So the scope has been toward greater protection of free speech. In the European Convention, the categories are open-ended, and you can add to them. We apply strict scrutiny here, although I agree with Steve that what that means is kind of up for grabs depending on recent decisions, and that is a very significant issue. In Europe, as opposed to strict scrutiny, they apply the concept of proportionality. Here, benefit of the doubt goes to the speaker. So we have what the Supreme Court has time and again called breathing space for free expression. Whereas you get the opposite balance in Europe, where they apply what they call a margin of appreciation. The margin of appreciation means, let's give the government the benefit of the doubt. They may really need to restrict the speech they want to restrict. And then here in this country, speech intermediaries, third parties who carry the speech of others online, are protected, partly by statute, partly constitutionally, whereas in Europe, the law as it is emerging is not so good for intermediaries. So again, very different systems, and it's one of the reasons why you have a very different approach to issues like hate speech. This is the second major area. Rule of law is critical. If we don't get that right, then we can stop right there. But even if the law is correct, even if we have protective constitutional barriers to government restrictions on speech, then we still have to worry about whether or not we are up to the task, whether or not we have the courage to be a free people. And that's what Justice Brandeis was writing about in Whitney versus California. Probably, and this is even before the Supreme Court had ever issued a single decision recognizing First Amendment rights. In his opinion in this case, he identified all of the essential values of what the First Amendment is about. But he goes on to write that those who want our independence believe that the final end of the state was to make men develop their faculties. They believe liberty to be the secret of happiness and courage to be the secret of liberty. So that if we don't have the courage of our convictions, then we're not going to have free expression. And we've seen this in the struggles for free expression throughout the 20th century. As Steve mentioned, it's really the second half of the 20th century that became so important. The struggles over civil rights, the struggles over the protesting the Vietnam War. This took genuine courage. People who were powerless fighting power, speaking truth to power, putting their bodies on the line, literally. It is through that demonstration of courage that we end up having the court looking at what was going on in the streets and reaching the right decisions. The same was true in the anti-war context, where we have the '68 Democratic Convention, we have war protesters, and then we have the tragedy at Kent State, where 4 students were shot by National Guardsmen. Again, it was through that period that some of our most basic formative First Amendment decisions were made. Now the question is, do we have that kind of courage today, even with the new kinds of challenges that we're facing? We've gone from facing the heckler's veto that tried to shout down protesters in the street during the civil rights movement to the assassin's veto. That is, people saying, if you say something I don't want you to say, I will kill you. We had sort of a threat of that with the release of The Interview, a not very good movie, but nonetheless, one that is not one of Kim Jong-un's favorites either. As a result, North Korea threatened the opening of and disrupted the opening of The Interview in the United States. It was nevertheless released to a limited way, and I felt it was absolutely essential. It was my duty to buy the DVD, so I did. Again, that was just a taste of it. But this was nothing compared to what happened the week after this was supposed to open. And that was the murders in Paris of the staff of Charlie Hebdo. The very thought that, well, 2 things, that it could happen, but also that opinion on it would be divided, to me, are a question of whether or not we really do have the courage of our convictions. So, for example, the week after the shootings, Charlie Hebdo had this cover, the All Is Forgiven cover, and you would think that American news outlets would have published this, given the magnitude of the events, the 1 million people who turned out in the streets of Paris, the demonstrations across the world. You would think it would have been a no-brainer in telling this critical story that they would publish this, understanding that there are going to be people who will be offended by it. And yet, in the United States, where we do have the protections of the First Amendment, the number of news organizations that actually published the Charlie Hebdo cover was limited. I think that raises a real question whether or not we do have the courage of our convictions. We saw this on this year's anniversary cover published last month, where Charlie Hebdo publishes this, not the prophet, but again, publishing an image with a god-like figure saying, the assassin is still at large. As you might imagine, this ruffled a few feathers. The biggest ones at the Vatican, saying that this was blasphemous, and I'm sure under a hate speech regime, potentially actionable. And so we have to ask whether or not in this new environment, in this age of global media and social media and threats by assassins, whether or not we have the courage of our convictions, the same kind of courage that led to the advances in freedom of expression during the civil rights movement. And then finally, the question of the spirit of liberty. Learned Hand wrote that liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. The spirit of liberty is the spirit, and this is my favorite line in this, the spirit of liberty is the spirit which is not too sure that it is right. The spirit of liberty is the spirit which seeks to understand the minds of other men and women. The spirit of liberty is the spirit which weighs their interests alongside its own without bias. Now, again, there was some allusion to this earlier when Greg Lukianoff spoke and talked about trends of belief in freedom of expression among millennials. And we've come a long way, particularly on the college campus. This is Berkeley in 1964, the birth of the free speech movement. Now, again, one of the things that I absolutely love about this picture, who shows up to a demonstration in a suit? But it was 1964, after all, a very different time. And the whole point of the movement was to allow the discussion of the pressing issues of the day, the hottest political topics on college campuses. Before that, speech was more limited to campus clubs and things like that, and there was a little area on the edge of the campus where you could actually talk about civil rights and other social issues. So this erupted in Berkeley in 1964, opened the campuses to political dialogue, and changed the course of the 1960s, and I think the course of American law. What we see on campus today is very different, where you have more and more university students of that age, favoring restrictions on speech, favoring hate speech laws, and at the same time being subject to campus speech codes. These are the same figures that Greg Lukianoff cited earlier in the first panel. And then you have some very well-publicized incidents, beginning with the ones last fall. This was at the University of Missouri. Melissa Click, actually formerly of the University of Missouri as of this week, saying that she needs some muscle over here to eject a student journalist who is taking pictures of a staging area for the student protesters. And then the infamous event at Yale, where you have confrontations on campus over a letter involving the propriety of Halloween costumes, and it erupted into a whole dialogue on campus. Now, this is not to say that there aren't many serious issues, sensitive issues of race and relations, civility, all of that. But the question is, are we going to create spaces where people actually want to be able to talk about those openly and honestly, or is the focus going to be to shut that down? Do we still have the spirit of liberty? So that's it for me.
Let me join with all the speakers in thanking Joel and the folks here at Brooklyn Law School for putting on a terrific panel. And I can see that Steve is leaving, but I had wanted to say one thing, and I know he's on his way out, Steve Shapiro. This is the first public gathering that I've been at since Steve announced his resignation, his actually retirement. Good for him. He's joining the rest of us who've passed the working age. His retirement as legal director of the ACLU. And I wanted to say, as someone who loves the ACLU, who, even though I disagree with it on issues of campaign speech, but who have devoted much of my professional life to the organization, how much I appreciate and am grateful for his remarkable work as legal director over these years. He was my successor. There was one short interregnum, John Powell, between the two. I know how hard that job is, and I know how wonderfully he performed it. So thanks, Steve.
Very sweet of you, Bert, and I'm glad to see that bottle of scotch work.
Let me also say, while I'm at it, what a wonderful, how nice it is to see Joel again. Joel and I worked together at the ACLU for many years. He even twisted my arm, made me sign the Buckley brief, for which I'm going to do much time in purgatory. But we've remained deep friends all these years, and it's good to see you. Is the First Amendment under fire? I think we all agree it's never been stronger doctrinally. There's never been a stronger court. The run of opinions over the last 15 years on First Amendment cases have created at least a doctrinal legal basis that is unmatched in the court's history. But I do think it's under fire. Not under fire from inside the legal world, but under fire from outside the legal world. Under fire from the community, both intellectuals and the folks who live live in the society that the First Amendment helps to shape. And I think the run of Supreme Court cases, and we can disagree and argue about particular cases and particular doctrines, but the run of Supreme Court cases have given the impression, and I'm not sure that it's wrong, that a majority of the Supreme Court uses the First Amendment as a device to prevent the government from regulating in areas where once upon a time they would use the substantive due process clause. And that the modern First Amendment, in the hands of some of the justices in the Supreme Court, has been a massive exercise in government deregulation, using speech as the lever to get into the deregulatory exercise, but that it's all part of a much larger agenda of taking the government, drowning it and shrinking it to the point where it can be drowned in the bathtub. And that the First Amendment has been used essentially as an attack on the very idea of government, the very idea of the legitimacy of government, and has left us with, for example, an electoral system in which there's massive disproportionate exercises of power, and a series of opinions in which the great grand idea of the First Amendment seems to be being used in ways that reinforce the powerful at the expense of the weak over and over again. And when the weak ask for protection, like labor unions, employees, or students, the Supreme Court doesn't give it to them. So that you wind up with the First Amendment as a one-way street that looks too much like substantive due process. Now, whether or not that's a fair critique, it is, I think, the diagnostic reason why people think that the First Amendment is under fire. They're rethinking a doctrine that leads them to those kinds of results. Now, Steve said something that I think is very important. Steve reminds us that First Amendment doctrine is a relatively young idea in this country. There's interesting stuff about the 19th century and very interesting stuff about the time of the founders, the Alien and Sedition Act, and the relationship of the founders' understanding of free speech to the words of the First Amendment. But the modern First Amendment doesn't really begin until the move from Dennis to Brandenburg. And that's only 1969. It's hard for us to remember that the first act of Congress that was ever struck down under the First Amendment occurred in 1965. So that this is a relatively new doctrine, that the way doctrine grows in our system, accretally in a common law way, with the court deciding case by case, with the doctrine slowly growing, with logic moving it around the outsides, we've been doing it about 50 years. And at about the 50-year point, in any complicated doctrine like that, people take a deep step back and start asking themselves, do I like it? Are we working out a doctrine that I feel particularly comfortable with? And I think, at the risk of predicting things that I really have no real knowledge of, I think we're going to see 3 points at which hard questions are going to be asked about the existing First Amendment doctrine. The first one is a split in the current court. The current court is now split 4-4 between 8 justices, all of whom profess great attachment to the First Amendment, but their attachment to the First Amendment takes 2 fundamentally different forms. The conservative justices that were led by Scalia, but now led by Roberts, the conservative justices view the First Amendment as a deregulatory tool. They see the First Amendment as a mechanism for saying to government, this is a particularly sensitive area. You do a lousy job regulating anywhere, but here, in the area of communication of ideas, you would do an appalling job. And therefore, any time you try it, because we're convinced you will do it badly, we're simply going to use the First Amendment as the opportunity to take you out of the game, so that you have essentially a deregulatory First Amendment based upon an assumption, that a suspicion, and maybe perhaps a well-founded suspicion, that the government can't be trusted with this kind of power, ever. And so it becomes a convenient way of advancing a deregulatory agenda. The 4 liberals, and it's interesting that they would come out with a different vision. The 4 liberals have an aspirational vision of the First Amendment. perhaps because they're willing to tolerate a much higher level of government regulation in the first place. The four liberals seem to think of the First Amendment as calling us to be better than we might otherwise be. I call it, you could call it a prophetic vision of the First Amendment, but it's an aspirational vision. It's the First Amendment as an effort at creating the ideal polity that we all hope we can live in, and that the First Amendment is the trumpet behind which they march. Now, most of the time, the two overlap. Because deregulation is often the way to build exactly the kind of polity that we hope. Nobody wants the government deeply involved in the flow of ideas. But at the margins, campaign speech, campaign finance being the most important, but other very, very closely contested cases, depending upon how the current court in the future views the amendment. If they view it as a deregulatory amendment, it's going to go one way at the margins. If they view it as an aspirational amendment, it's going to go another way at the margins, and which of course means that the new appointment is crucial, because the new appointment creates a balance of power on whether you have a deregulatory or aspirational view of the amendment. The second battleground that I think there will be is a deepening of the understanding of the nature of the communications process. If you had to build a census of, I call it Mr. Madison's neighborhood, the First Amendment, the communications universe, the First Amendment's universe. If you took a census of Mr. Madison's neighborhood, you would have 5 players. There are 5 repeat players in the communications process. There's the speaker, there's the hearer, there's the conduit that transmits the speaker's voice to large numbers of people. There's the target that the speech is about, and there's the regulator. Now, under existing First Amendment doctrine, the speaker is assumed to be Prometheus shouting at the gods. There's a heroic speaker whom we reinforce as part of Justice Brandeis's idea of the inherent dignity of the individual, and the speaker is the aristocrat. The speaker is the neighborhood aristocrat. The hearer is kind of like a haute bourgeoisie. He's important, or she's important, but when the interests of the hearer and the speaker collide, the speaker almost always wins, because the speaker is considered to be more significant. The target, the person that they're talking about, is the neighborhood slum dweller. His or her interests are always subordinated to the interests of the speakers and the hearers, and American libel law is a perfect example of it, that there's not much protection for the targets of the speech. Then there's the conduit. The conduit are the neighborhood arrivistes. They've dressed themselves up as speakers. They're really just mechanics running a machine to get the speech, but they pretend that they're speakers, and they've persuaded the Supreme Court to treat them as speakers, and not just as conduits, as mechanics. And then the fifth is the regulator. The regulator is the neighborhood motorcycle gang, and if you give it any traction, it'll trash the neighborhood. Now, what we're going to see, I predict, in the next 50-year cycle, is a deepening of the discussion of what the First Amendment universe is really about. For example, is it really true that the motorcycle gang will trash the neighborhood if you give it any power at all? How is it that that same motorcycle gang has run a system of public education for 150 years in the United States, which is not great, but it is not a systemic exercise in censorship? In fact, there's more open discussion in the public schools about hard questions than there are in many of the elite private schools, which tend to be genuine ideological Xerox machines. So the notion that somehow the government will always turn into a censor is a very good argument if you have an authoritarian government or a dictatorship. Censorship in a democracy is a little harder to do. It can happen, you've got to be very careful about it, but the notion that you can't give them any power at all, because if you give them any power, it'll be disastrous, is something that I think we're going to have to rethink. The second thing I think we're going to have to rethink is the role of the hearer. The hearer after all, if you went out in the woods and spoke in the forest and nobody heard you, maybe Brandeis would think that was a good thing because you were self-expressing. But if you think nobody heard you, you wouldn't think you were doing anything important. Speech is important only because people hear it. And speech is important only because they will be moved by it. And so at some point we need a much richer conception of the role of the hearer. We have a totally speaker-centered jurisprudence now. We're going to, I think through a little more deeply the role of hearers and when hearers should be protected or can be protected against speakers, to simply, limit the notion that First Amendment is all about the power of a single powerful speaker to beat the hearer until the hearer is, either does what the speaker wants or moves away in some other setting. And so I think that's going to have to be rethought. The last thing I think that will be rethought for sure is the role of the conduit. As you get these major companies, The Nation had an article a couple of years ago, I never checked the facts, but their argument was that 7 major corporations controlled virtually all speech in the United States, everything. The book publishers, the movies, the internet and the television studios, and it all funnels into a series of corporate power at some very, very high level. Now, that's I don't think they sit in a dark room and censor me, but I do think that they have an extraordinary amount of power about what gets said. And the idea that if you prevent the government from regulating, all of a sudden you have a free speech market is simply an empirical lie. If you take the government out of the game, somebody regulates traffic in Mr. Madison's neighborhood, and that somebody is a very powerful private entity exercising private power. Now, if you had to make a choice between the neighborhood motorcycle gang and the very powerful private entity, I'm not sure that the neighborhood motorcycle gang is a greater risk than the entity. And finally, I'll just say one word. Bob was kind enough to mention my book, and I really do thank you, and you'll get your cut, I promise. The last thing is, I think we're going to look harder at the text of the First Amendment. My book is all about the fact that when I graduated from law school in '64, we never cared about text. Text didn't matter. It was the great achievement of Justice Scalia to force us to come to grips with text. I used to think of text as a kind of translucent event that I would go through in search of a deeper truth. Sometimes I'd be looking for harmony, sometimes I'd be looking for justice, sometimes I'd be looking to carry out what I understood to be the purpose of the democratic system. But the text itself was the beginning of the enterprise. It was not the end. Now, Justice Scalia invented the idea of opaque text, where you go up against the text, but you can't go through the other side. And you've got to struggle with the words on the page in a way that I never did when I graduated from law school. I never did through much of my career as a litigator. But the force of his intellect was such that he changed the way we thought about that. And that's a remarkable achievement, and probably is going to go down as his greatest achievement as a lawyer. So I decided to take a good hard look at the First Amendment. Here, I'd litigated hundreds of First Amendment cases, and I confess to you, I had never read the damn thing. I knew what all the cases said about it. I knew that there was something called the First Amendment, but I never really wrestled with the verbs and the punctuation and why one word was there and another word was somewhere else. So I spent a summer reading it really, really closely, all 45 words. And you know what? When you read all 45 words, something remarkable happens. First of all, the First Amendment, it has 6 ideas. It has establishment, free exercise, speech, press, assembly, and petition. 6 ideas in 6 separate clauses, 45 words. No rights-bearing document in our cultural history has the same 6 ideas in the same place. Never. Not from the Magna Carta, not the English Bills of Rights, not the state constitutions, not the charters of the various colonial governments, not the Declaration of the Rights of Man, nothing prefigures those 6 ideas, and nothing has them in the order that Madison put them into. Madison's genius was organizational, not substance. Not a single right in the First Amendment didn't appear at least 3 times in one of the antecedent texts, but nobody conceived them in the order that he did. And from the very first minute that he introduced what eventually came to be the First Amendment after all the editing, on June 8th, 1789, the very first introduction has the chronological order almost exactly perfect. And the chronological order is the life cycle of a democratic idea. The religion clauses protect the interior conscience of a dignified human being. You cannot be told what to believe, and you cannot stop someone from acting out what they believe. Once that freedom of conscience occurs, you're going to have an idea. You want to then express that idea. That's why the speech clause comes third. Once you express the idea, you can't change much unless you can get it mass disseminated. That's what the press clause is about. It takes the idea and brings it to a mass audience. Once the mass audience has it, the next step is collective action, and that's the assembly clause, where collective action steps in. And once collective action is over, the petition clause is how an energized people takes the idea and moves it to the government and demands that they adopt it or oppose it, either way. So that, I don't think the founders took a pot of ink and threw it at the wall and let the splatter decide the order of the First Amendment. There's an intelligent animus there, thinking about it. Now, even if Bob's right that I can't go back and recapitulate what they thought, I don't care what they thought. I'm not talking about originalism here. I'm talking about Scalia's real lesson to us. Look at the text. And if we have the miracle of a text that just happens to replicate the life of a democracy, the life of a democratic idea, that's a great gift to us, and we shouldn't waste it. And the modern Supreme Court reads the free speech clause in a clause-bound way. It has establishment clause cases, it has free exercise cases, it has free speech cases, it has free press. Never tries to put the whole thing together in a coherent whole. Now, whether my argument on structuralism is the argument that goes forward or someone else's argument, as there's lots of intellectual ferment going on now, but what I predict is that there will be a future in the First Amendment where people look hard at the whole document and say, how do we make the whole document work? Not create an imperial free speech clause that conquers the press clause, wipes out the assembly clause, eliminates the petition clause, and is now slowly but surely eating up the religion clauses. We will not have an imperial free speech clause, but a truly coherent, harmonious First Amendment. So I think we're going to have an interesting 50 years.
Well, thanks very much. I can't believe how Bert Newborn ended his talk, because I'm going to begin mine in the same place. That is, I think when we're thinking about the future of the First Amendment, we should think about the whole First Amendment and not just the speech clause, which has been the focus today. And I think that the focus for today has been totally appropriate. But I think it makes sense at the end of a day like today to think well, how would the speech clause fit together with the other constitutional provisions that we have, especially in the First Amendment itself? In my remarks, I'm just going to focus on the religion clauses and the speech clause, because I think that's enough for 10 minutes. But I think Bert Newborn is totally right that we should think about the speech clause in its context, its textual context, and also its normative context. And so I'm going to do a little bit of that work today. But before I do, I just want to thank Joel again, just to add to the chorus. This has been a great... This has been a great event, and I'm really honored to have him as a colleague and to be part of it. So I've been working on a book about the current conflicts between religious actors and equality law. So think of disputes about wedding photographers or clerks who don't want to hand out marriage licenses and employers who don't want to implement the contraception mandate. But at the same time, I've been teaching First Amendment law, and in the First Amendment course, I teach both parts of the First Amendment, the speech clause and the religion clauses. And when you do that, you can't help but recognize that many of these disputes concern religion and speech together. So think of the Christian Legal Society against Martinez about a university's decision not to recognize a conservative religious student group because of its positions on LGBT practices. That was a speech case, although of course it was crucially about religion as well. Or think of Elaine Photography, which was about a wedding photographer who ran afoul of public accommodations laws in New Mexico. The company claimed defenses sounding in both free exercise and in freedom of speech. So once you start to see the connections and you start to think about how the doctrine is structured, and one thing I've noticed is that there are parallel doctrines in the speech area and in the religion areas that are conceptualized totally separately by the court, just as Bert Newborn was saying. And perhaps as a consequence, the way that the court treats these problems is different in virtually every one of these areas that I've identified. But that seems strange once you start to reflect. The scholarly background for the puzzle is that there's been an argument among academics that's been building steam in recent years that religion ought not to receive constitutional solicitude that's kind of special, that there aren't good normative reasons for treating religion differently from other deeply held beliefs and practices. There's also been a quieter, but I think still persistent, questioning of whether speech is special as compared to conduct that's animated by ideas and convictions. And there's not a great answer to that question either in the speech literature. When you put them together, you start to think like, gosh, there's a real problem here, and in the future of First Amendment law, the court's going to have to figure this out, and we're all going to have to work on it. So what I want to do to get today in our short time together is just sort of lay out the problem. To the extent I have an argument, it's just that this problem will be a part of the future of the First Amendment, and it's going to be an important part of it, I think. These arguments aren't going away, they keep recurring. So let me give 4 examples of areas where there are parallel doctrines, but the answers are different, with the exception of the 4th, where right now the doctrine is the same, but there's a lot of pressure. First, incidental burdens on the right. So both in the speech area and in the religion area, there is a question. And the question is, what happens when the government doesn't target the right for particular regulation, doesn't target speech for regulation, or doesn't target religion for regulation, but instead passes a law that happens to burden speakers or believers disproportionately? In religious freedom law, the rule is set out in a case called Employment Division against Smith, and it's basically that religious actors are not protected against general laws that just happen to burden their observance. So in that case, the example was the drug laws, which prohibited Native Americans from using peyote in their sacred rituals, and the answer of the court, in an opinion by Justice Scalia, was tough luck, you're out of luck. When it comes to free speech, however, the doctrine is different. There, incidental burdens on the right trigger intermediate scrutiny, which is not some kind of free-floating balancing test, but shifts the burden onto the government to show that it really needs this law. So there's a presumption of unconstitutionality that attaches when free speech is challenged by a neutral law. In the case itself, O'Brien, the person O'Brien was held liable for burning his draft card, which was conduct that that had an expressive import for him. So you might ask, why would the rule be different? Why would we have a different approach to incidental burdens on religious freedom than we do to free speech? I think it's really hard to think of a good answer. Now, in practice, of course, things aren't so clean. Free exercise is protected against incidental burdens by statutes. The most famous one right now is the Religious Freedom Restoration Act, which was the statute at issue in Hobby Lobby. Moreover, there are some state analogs to the Federal Religious Freedom Restoration Act, and there are state constitutional provisions that are read sometimes to protect incidental burdens on religion. So it's a little more complicated in practice. Also, even just thinking of the federal constitution, the rule of Smith has several exemptions that lower courts have used to actually relieve people who are subject to incidental burdens on religious freedom. So it's a little messy. And on the speech side, the O'Brien test is not as speech protective as it seems to be. O'Brien himself lost, and many others in his position have lost as well, such as the homelessness activists who wished to camp across the street from the White House and were denied the ability to do that. But you could argue that those caveats only work to kind of reinforce my point. If there really is no good reason for differential treatment of speech and religion in this area, you would expect to see courts kind of blurring the doctrines to achieve justifiable results, and that's exactly what you do see. The second area is freedom of association, which is not, the main area of speech law, but it is an important area of speech law, and it's becoming increasingly important. In particular, the ability of groups to choose their leaders without interference from civil rights laws is a question. In a case called Boy Scouts against Dale, the court protected the Boy Scouts' ability to dismiss a gay troop leader despite New Jersey's public accommodation statute. The court cited the expressive interests of the group in forming and implementing its mission. And in Hosanna Tabor, which was a religion clause case, the court protected the ability of a religious school to fire a teacher who was ordained, despite the fact that she otherwise would have been protected, it seems, under the civil rights laws because she suffered from a disability and or because she was fired for complaining about the way she was treated to the EEOC. So these doctrines seem to be similar, but actually, they are meaningfully different. So the Boy Scouts can discriminate in employment only if they can show that their reason is grounded in the organization's mission, that there's some connection between their ability to express their ideas and their ideas themselves and the discrimination that's in question. And they get deference on that question, but they still have to make the case. Another way of putting it is that secular groups have to show that the government regulation is actually burdening their expression. Religious organizations, by contrast, do not have to show that the reason that they're discriminating for firing a clergy member was connected to their theology. There have even been cases in lower courts where the group's theology prohibited discrimination on the basis of, say, gender, but the group still got deference from the court or protection from the court when it fired someone allegedly because of their gender. This is the, quote, ministerial exception, as it's been called by the Supreme Court. The ministerial exception is stronger in another way, too, than its secular analog. Once the congregation shows that the employees, by contrast, still have to work through the compelling interest test if they want to get protected. So again, the question is, why do we have these differences? If religion doesn't deserve special constitutional solicitude, as many people believe, it's hard to come up with a reason. And in fact, the Solicitor General of the United States argued that Hosanna Tabor should be resolved under the Boy Scouts rule. Because, or in a way that was consistent with the idea that religion is not special, but the court dismissed that argument quickly and with unanimous vote, and even if its reasoning was opaque, the idea that religion is special is kind of, for the moment, enshrined in constitutional law. One possibility is that we don't want courts examining religious doctrine to see whether a form of discrimination really is commanded by a theology, but that could be solved by the kind of deference that the court affords secular groups. The third area, non-establishment. So a lot of people would say, well, if there's a difference between freedom of religion and freedom of speech, it's that there's no establishment clause for secular speech. That's something that pertains to religion only and sets apart religious freedom writ large, the idea of religious freedom, from freedom of speech in America. But even this isn't so clear in my view. After all, lots of provisions in the Constitution limit what the government can say, at least I think if we think about them the right way. So officials cannot endorse the message that America is a white nation any more than they can endorse the message that America is a Christian nation. Now that limitation sounds in equal protection, although I would argue that it has important free speech roots as well. But other limits on government endorsement are rooted in the speech clause itself. For example, the government could not say, vote Democrat. And the best understanding of why leads back to structural aspects of the free speech clause, its function of protecting the full citizenship of every American and their ability to fully participate in politics on equal terms. You could think instead of political gerrymandering. So we don't have a constitutional rule against it at the moment, but Justice Kennedy has suggested in an influential opinion that the most promising theory for the unconstitutionality of political gerrymandering is rooted in the speech clause and under a very similar theory of full citizenship participation. The fourth area, of course, is corporate rights. So do for-profit business corporations have the right to exercise their speech abilities, and do they have rights of freedom of religion? In Citizens United, as everyone here knows, the court finally and fully acknowledged that business corporations have speech rights, And then, without citing Citizens United, the court more recently held in Hobby Lobby that business corporations also have free exercise rights. Even people who acquiesce in Citizens United, though, have opposed Hobby Lobby, arguing that while business corporations may speak, they definitely don't pray or practice religion. But it's there too, it's sort of difficult to think of a reason why not. Here's a hypothetical. Imagine a sole proprietor who runs a business. One day, she decides to incorporate for business reasons. Nothing else changes. She remains the sole manager of the business and its sole shareholder. And everything else is the same. No one doubts that she could exercise religious freedom before she incorporates. Why not afterwards? There might be an answer to that. I'm kind of working on an answer, but it is at least not obvious. Moreover, there are some corporations that everyone agrees are protected by the religion clauses, namely houses of worship themselves, almost all of which are incorporated. So any theory would have to differentiate not just between corporations and individuals, but among types of corporations, and possibly among types of other business associations as well, such as general partnerships and so forth. Now, there are some possible answers here, and we can explore them in the question and answer session if you want. But my only point is that this is one area where the court has brought harmony to the doctrine, right? So speech and religion are treated in the same way here, but it's been met by lots of pressure, especially from the left. So where does this leave us? I think it just leaves us with a bunch of questions, but they're good questions, right? They're questions that will shape the future. So what is the most attractive locus of the rights that we have in the First Amendment? What attribute or activity can unite them? If religion isn't special, and if speech isn't special, although I haven't really mentioned that yet, or touched, sort of analyzed it, then maybe we should protect conscience or belief or opinion. There are some constitutions that have liberty provisions that do that. So they protect conscience, thought, belief, and opinion. The South African Constitution is one like that, but it's modeled on international instruments. If we were to make that kind of change or understand our own First Amendment in that way, what would our jurisprudence look like? Another question is how we should protect whatever attribute or activity we isolate. Should we level up, affording the highest level of constitutional solicitude that we currently have in our jurisprudence, or should we level down and treat them all the same but with less solicitude? Would the former present unacceptable risks of anarchy or at least arbitrariness? Can we imagine a constitutional jurisprudence that protected the right of conscience, for example? What would that look like? Whatever the answer is, we should start to realize that I think they'll surely influence the future of the First Amendment.
Thank you, Nelson. So we had 4 really, really wonderful presentations. I really hesitate to have too long a Q&A because we were already over time. Having said that, I can't resist the urge to ask a very hard question and demand a very quick answer from each of the panelists. And that is this. You've all identified what I would consider pretty big issues that are faced to First Amendment and free speech generally over the next 50 years. How confident are you that we have the analytical tools and, in your case, Bob in particular, the courage of our convictions to respond to those large challenges you've all identified?
That last question that you identify is obviously the most difficult one, the courage of our convictions and the spirit of liberty, those two, because those are completely out of our hands. They're in the hands of the coming generation and those after them. If they're, and for the entire system, by the way, the entire constitutional republic, whether or not there is an interest in maintaining it and understanding in maintaining it. The doctrinal tools I think we have down pretty well, and I think the Supreme Court has been on the right course in protecting speech. But I see that debate is coming. Bert is absolutely right that it does recur from time to time, and I fully subscribe to Bertrand Russell's statement that every now and then it makes really good sense to take your deepest convictions and put a question mark after them. And so I think it's important to do this kind of reexamination. And I really admire Bert's writing and his career. He's been a First Amendment hero of mine for a long time. But when it comes down to looking at where the doctrine is going and where it should go, then I do have some differences with him. And I think that, that will be sort of the battle for the soul of the court going forward. And, you know, I could listen to Bert all day, couldn't you? I mean, it's wonderful. And the problem is he's completely wrong. If the question is, really is, what is your narrative? And he's created this wonderful narrative for how we're supposed to look at what the court is doing, how we're supposed to imagine Mr. Madison's neighborhood, all of those things. It reminds me of the quote that Floyd Abrams used this morning from the Austin case that says that the Constitution will be brought down not by brute force, but by poetic metaphor. And I think that's what we're facing here. Looking at what the court's doing now, is it really a deregulatory agenda versus an aspirational agenda? Really is a court that is trying to use the First Amendment to deregulate? I mean, the cases that bother him the most involve a guy who made dogfighting videos and training videos for pit bulls, the Westboro Baptist Church, a loser in California who lied about having the Medal of Honor, and a case about video games. That's the rich and powerful. That's the deregulatory agenda. I mean, if you really want to look at the First Amendment cases where the court has not pursued a deregulatory agenda, look at Fox Television versus the FCC, or CBS versus the FCC, where the court had every opportunity to take out whole sections of the content regulatory provisions of the Communications Act. It chose not to do it. It upheld the FCC first on administrative procedure grounds, and then when we had the case go back, it struck down the FCC, but on very narrow due process grounds, leaving the regulatory structure in place. It had the perfect opportunity to do it, and chose not to. So, you know, if I'm given a choice between deregulation, bad, or aspiration, good, then it sounds like an easy choice. I'll go with aspirational, but I don't think that's what the court's doing. I don't think that's how the interpretation of the First Amendment works. And so I think the court, in its current view of the First Amendment, is really on the right track, and the question is whether or not that will continue.
Well, first of all, I'm never appearing on a panel with him again. Because he has a needle that punctures my balloon a little too well. It's a mutual admiration society. I've admired Bob's work for years. Let me answer the question. I am very confident that we, as a nation, possess both the analytic, I'm not even sure tools, but the analytic infrastructure to work through the questions of the First Amendment in the next 50 years and work them through well. And I have enormous confidence in the capacity of the nation to work it out. I mean, you know, we are not a nation in which the Supreme Court is a deus ex machina that drops down laws and saves us from ourselves. We are a nation where the makeup of the Supreme Court is a reflection of the society that wants it. You nominate, you elect presidents. Presidents appoint Supreme Court justices, if they're allowed to, and the Supreme Court evolves. It's been that way through the nation's history. We don't have a hermetically insulated judiciary that is our master, that tells us what we want. What we have is a judiciary that slows us down, that says if there's going to be fundamental change, let it be over a long period of time, with a series of political reinforcements at the polls, and a long time to talk about where we want to go. That's how we got from substantive due process to where we are now, and it's how we'll get through our First Amendment questions as we do it now. And so the answer is I have a great deal of confidence that we are going to get it right. And getting it right, to me at least, is tinkering just a little bit at the margins. Now, Bob is going to say you tinker a little bit at the margins, camel's nose is in the tent, and therefore you're not going to be able to stop it. But that's a slippery slope vision that really says that it's the motorcycle gang vision, and I don't mistrust our government that much. I mistrust it a lot.
You didn't work at the FCC.
Well, it's true. It's true. It's true. I've never been in government, which is probably why I don't mistrust it. But I have faith in the fact that we, as a people, can work this through. And I hope to be here 50 years from now when Joel does his next 50-year conference, and I'm going to be here to talk about it.
We used to have a saying when I worked at the FCC, it's a good thing we're not the Consumer Product Safety Commission. Someone could get hurt.
I'll just be very brief, but I agree with Bert Newborn about this. I have tremendous optimism in the ability of the people. Some of my students are here, which I'm grateful for because they did not need to be here, and it's late. But if they're as motivated, about these ideas to show up at something like this, then they're motivated to go out and change the world and influence the court and make sure that our government is doing what it should to make sense of these ideas. And that's not because the deregulatory impulse, which I totally agree is there, and it's there not just in the speech clause, but also on the religion side, think of Hobby Lobby, isn't dangerous. I mean, these are not small cases with small individuals who are quirky. Hobby Lobby had thousands of employees, and on the basis of, in reliance of that decision, many other business corporations were able to exempt themselves from a major regulation that was designed to protect women's health. So this is not small. There's another case pending in front of the Supreme Court to do with nonprofit religious employers on the same issue of contraception mandate. That's a big issue. Citizens United, that's a big case. That's not a small thing. It's not an isolated individual. So I don't have this optimism because I think the problems are small. The problems are big, and it is a deregulatory moment in First Amendment law. But I do think that there's pressure being brought on the court, and there's support being brought to government actors who are trying to push back against this, and we'll get it right. And that's not because there's nothing to the First Amendment. It's not because these questions aren't hard, but that we have the ability, the discursive will, and the analytic tools to get the right answer.
Great. So on that note, please join me in thanking our panelists and thanking Joe Gore for a wonderful day.